Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Phoenix, Arizona on January 11th through the 12th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and in this episode I am pleased to be joined by David Pere. David is an attorney in the Paris office of Bryan Cave. Welcome, David.
Thank you very much, Mike.
We are going to be talking about developments in France, and I was hoping you could start by describing for the podcast listeners the so-called Sapin II law and other developments in your country as relevant to the anti-corruption and bribery space.
Thank you very much. We have a new law in France called Sapin II from December 9, 2016, which wants to fight against corruption. This law is called Sapin II because we are the first law anti-corruption which was suggested by the same individual, Minister Michel Sapin, back in 1993, so a long time ago. This law really wants to fight anti-corruption in France, and so it creates a whole set of new measures. First of all, we have a new anti-corruption agency which we didn't have beforehand, and this is called the AFA, Agence Française Anti-Corruption. This law also creates a new criminal offense and expands the existing criminal law against corruption in France. It creates also new means of prosecuting corruption, and we will speak about that later. It creates a whistleblowing mechanism, and finally, it imposes new obligations for companies. Now, French companies have obligations to create a compliance program. What does this mean? Companies have to now have a compliance program with 8 mandatory components. They have to do risk mapping, they have to do an anti-corruption code of conduct, a disciplinary procedure action policy, they have to create internal warning procedures to check the integrity of customers and direct suppliers, as well as intermediaries. They have to conduct third-party risk assessment, internal and external accounting controls, and finally, they have to provide a training for the most exposed employees. This new compliance program is not suggested, it is mandatory to all companies organized under French law and groups controlled via France with over 500 employees and annual revenues of 100 million euros. So this is a big revolution in France, and it is a case because the failure to comply with this new law and to have such a compliance program is sanctioned by the new anti-corruption agency. we are talking now about fines which can go up to 1 million euros for companies and 200,000 euros for individuals, which can be held liable for not implementing this compliance program.
I've seen several presentations or read several things about this new law that, seemingly take for granted that those within companies who will be in charge of these anti-corruption programs have a clear understanding of what corruption actually is from a criminal law perspective. Does this new law bring anything new substantively in that respect that general counsels, compliance officers, and others within a company should know about?
Well, as I said, this new Sapin II law not only creates all these obligations to have a compliance program, it also changes the core of criminal law in France. Basically, beforehand, before Sapin II, when you had a French company or French individual who committed acts of corruption abroad from France, France could only act and prosecute those actions if very strict conditions were met. We had to have reciprocity of incrimination. This means that beforehand, if the French national, the French company committed an act in a country, for example, in South Africa or in South America, in order to prosecute those actions in France, we had to check if those actions were prohibited in the said country, which was not always the case, of course. And we have also the requirement that the prosecution should be made by the French prosecutor following a complaint by the victim, which was a very difficult condition. Now, this new law changes everything. Basically, for acts of corruption, French law applies to actions by French nationals or French companies committed abroad without any more without any new condition. So it means that it is very easy now for French authorities to prosecute actions committed by the French nationals and the French companies which are committed abroad. We have a new offense which is created by the French law, which is French trafic d'influence for foreign agents. Beforehand, we had only the foreign corruption which was prohibited, but not the trafic d'influence. What does it mean? It means that if you had a French company or French national abroad, which would go and try to bribe someone in order to use his or her influence to get some advantages, this was not prohibited in the French law. This has changed also, and so you see, with those two measures, Sapin II law is not only creating a new set of obligations to prevent corruption, it also gives to the French authorities new means to fight and to prosecute corruptions committed abroad.
Now, there have been a number of instances of French companies, largely French companies with shares traded on a U.S. exchange, resolving FCPA enforcement actions, and presumably because of those enforcement actions, French companies, or at least certain French companies, have been implementing FCPA best practices, perhaps for a number of years. If a French company has otherwise been acting consistent with FCPA best practices and fully compliant with the FCPA over the last several years, does that mean that those companies are therefore acting consistent with French legal obligations, including these new legal obligations?
Well, I think this question is very interesting for the French companies you mentioned, but also for the U.S. companies or for the foreign companies that are compliant with FCPA and go to do business in France and get to the thresholds we just mentioned, because the new Sapin II law also applies to them. Well, I think you have two kinds of answers. First of all, about the compliance program. The compliance program I just mentioned, those 8 points which are now mandatory in the new law in France, well, if I understand correctly, the FCPA law in the US, in the USA, to have a compliance program is not compulsory. It's not per se an offense not to have a compliance program. In France now, it is the case. So it means that the mere failure to have those 8 points we just mentioned can lead to a fine up to 1 million euros. So this is my first answer to your question. If you comply with FCPA, if you are a French company, or if you are a U.S. company which works in France, and if you think that that's enough, well, I think you should review the new law to make sure that you comply with those 8 points, which are not only a mere suggestion, but which are mandatory.
And let me just stop you. Let me just stop you there for listeners' benefits. The FCPA, at least as applicable to publicly traded companies or issuers in FCPA speak, you're right in the sense that the only statutory obligation for those companies is to have internal controls adequate to provide reasonable assurances that certain of the financial objectives set forth in the statute have been met. And of course, much of the consternation from a U.S. Business standpoint is they're implementing rules or regulations that really specify what an issuer is supposed to have to meet those requirements. So I just wanted to add that in there as relevant to your reference to the FCPA.
Thank you, because you are the FCPA professor, not me. I have another answer to your question. The other answer is, what should companies do to prevent accusations of bribery or corruption? And for example, we know that in some instances, for example, if we have a company which is making business in a port and which is being hit by the local police or local port authorities, this company might think that under FCPA they could sign an agreement with the state or with the local authorities and therefore not pay any private person, but pay have a written contract which is serious, and pay to the port authorities a sum in order to get protection, and this could avoid FCPA accusation of corruptions to private individuals. So that could work under FCPA from what I understand. In French law, I think that could be much difficult to prevent accusations of corruption. And we have a case now in France which was tried, which is the famous case Oil for Food, where Iraq was accused of not respecting the UN embargo, and we had a lot of oil companies which dealt with Iraq in violation of this embargo. And one of the accusations was foreign corruption, and the company said, well, we're not corrupting any private individuals because we are paying money to the state, Iraqi state. So this cannot be corruption. And this did not work in French law. So if you are FCPA compliant, if you made all the necessary measures with the U.S. lawyers in order to avoid being prosecuted under the FCPA, it doesn't mean that under French law everything is the same. I strongly recommend people to look at this new law with a French counsel, which could really advise better if the FCPA solutions apply to the French new regime.
What can you tell listeners about this new French anti-corruption agency that you mentioned, the AFA? What do we need to know about that agency?
First of all, what your listeners should know is that this agency is led by a very interesting figure, Mr. Charles Duchesne. Mr. Duchesne is a very well-known figure in France in the political and judicial system is a former judge, which is known for being very bold and very imaginative. So this is a political gesture to appoint such figure, which is a very respected, hard-working judge to head this new agency. The message is very clear. We are serious about corruption. We are appointing someone who is a serious person. It's not, a phantom or a ghost. It's someone who is really going to work hard to lead this agency to the top. Now, the new agency just today published new guidelines for to help the companies to prepare and to comply with this new law. So I think your listeners should know that there are those guidelines which are just published and which are going to be finalized by the beginning of next year. We are now in the process of writing comments of those guidelines to the AFA in order to have finalization of all this by the beginning of 2018. There are two more things that your listeners should know. First of all, the AFA published what we can call a Charter of Rights, but it is more adequately a Charter of Rights and Duties of the companies who are being controlled. And it is very interesting because it stresses all the duties the companies have. And one thing which is very interesting is that those companies have the right to be assisted by lawyers during the control, which was not completely logical or which was not completely written by the law, so we are very pleased to learn that. And now, as we are in the middle of this public consultation and of this publication, well, the AFA has just started to control the companies. And so on October 10, Mr. Duchesne signed letters to 6 companies, and they requested a very detailed list of documents, and they announced that the AFA is going to come and control on the premises. So this is a very interesting timing, because one could have thought that in the process of publication of these guidelines, the AFA would have waited before all those guidelines are finalized to start the controls. It is not the case. The AFA is starting the control right now. So I think it is a political gesture also to say, we really want to do this. We are very serious about fighting corruption. And I think people should get ready in France to fight or to prepare for those controls.
Now, in the United States, non-prosecution agreements and deferred prosecution agreements really over the last decade or so have become the predominant way in which corporate FCPA enforcement actions are resolved. Does France have, under this new law, something similar to these alternative resolution vehicles that are so prominent in the United States?
Well, actually, this new Sapin II law created a new legal object, which is called CJIP, for Convention Judiciaire d'Intérêt Public, and which is similar to those agreements, because it only applies to companies and not individuals. In these agreements, you have no admission of criminal guilt. You have no inscription on your criminal record of this condemnation, because it is not a criminal condemnation. But you can be imposed a very, very high fine, and you can be subject to monitoring also. And so this means that there is now a possibility to follow the U.S. example, which you mentioned, for companies who are prosecuted by the French authorities. And what I want to say is that yesterday was published the first CJIP, which was concluded by the French prosecutor, and it concerns a very well-known bank, a major international bank, which was sued for tax evasion, and they agreed to pay the sum of 300 million euros according to this new agreement. And I have to say that this is apparently the highest fine which was ever pronounced by French criminal courts. So I think the message is clear. Now the French wants to be taken seriously anti-corruption, so they're going to fine very heavily the people or the companies which are prosecuted, and they want to show the world and the USA also that they're not behind on the fight anti-corruption, and they probably want to show that they are leading the way.
There's been so much written in the last, several years in the FCPA context and otherwise, including money laundering cases and Bank Secrecy Act cases against French banks about the United States law is perhaps overstepping their bounds in bringing enforcement actions against French companies. I know that has been a much talked about public policy issue in France. Can you just give us your perspective on this dynamic?
Well, for sure, French authorities and French companies executed abroad by the U.S., sometimes with a very tenuous link to the U.S. soil. As you are well aware, sometimes the link to the U.S. jurisdiction is because some transactions were made by through U.S. dollars. And of course, I don't think French companies and French authorities see that are very happy with this situation. What I can say is that clearly the creation of a new agency in France and all the sets of measures is made in order to show the world and the USA that France now really wants to prosecute companies seriously. So I think it's going to be now a political discussion between maybe France and the USA in order to try to convince the United States that since we are acting seriously now against French companies, maybe under the principle of committee, USA should not or could not bring another legal action for the same facts. You know that, I'm sure you know that sometimes people or companies are prosecuted several times under the same, for the same facts, but by various jurisdictions in the USA, in the UK, and in France. And we know that in some instances, French courts have admitted that because someone had been prosecuted in the USA and had entered a non-prosecution agreement, for example, well, he could not be prosecuted again in France. I think that the whole political symbol behind the creation of this new agency and this new set of rules is to try to convince our American friends that now should be the time for the U.S. jurisdiction also to take into account what France is doing anti-corruption and to prevent double prosecutions in our two countries.
Today's guest has been David Pere. He's an attorney in the Paris office of Bryan Cave, and I really appreciate you joining me today and educating FCPA Flash listeners on some of the developments in the anti-bribery and corruption space in France.
Thank you very much.